In paragraph 123 of the interim judgment of the Supreme Court, which came on 12 September 2025, the court observed, and I quote, as early as in 1923, it was noted that instances of such misuse of trust property were unfortunately so common that a Waqf endowment had now come to be regarded by the public as only a clever device to tie up property in order to defeat creditors and generally to evade the law under the cloak of a plausible dedication to the law. In fact, it was actually one of its kind because the Hindu legislators could not even introduce a similar bill because of expected backlash. So the Waqf Registration Act of 23, by making trustees of religious and public charities accountable, was encouraging transparency in an area that the Hindu trading communities were keenly fighting to 6. The Delhi Waqf Act should be amended to exclude notification of government property as well, which is what is now coming in 2025. So nothing happens in a day, right? That mentality builds up. That attitude is there. It just, in the late 1950s, the central government took a decision to relinquish. Now here comes the Nehruvian India, where actually it did come up with some interesting and quite liberal policies. So the family Waqf beneficiaries were again divided. A lot of brothers. Thank you very much, and thank you to the organizers actually for giving us this opportunity and for getting a wide section of stakeholders, I would say, to come here and contribute to this very important aspect that is now animating a lot of Muslims communities in India, and rightly so. So my name is Danish, and I've flown from UK, just like Mr. Dawoodi, our moderator. I was a journalist in Bombay before coming to UK. I continue to write and report from London and Europe for various media organizations, but I also did my master's at King's College London, and then I recently defended my PhD at University of Oxford in the history faculty, where I look at, or rather I examine the Muslim trading communities of colonial Bombay. But today I'm here to speak on Waqf. It's not entirely a subject of my research, actually, not part of my PhD, but yes, there are certain aspects of it that come out. And as I said, because by virtue of being a journalist, I do write and report on a host of issues, large variety of issues, and Waqf has been one part of it. So I'm going to speak today on Waqf, but from a slightly different, not slightly, I would say, from a bit of a different angle, because there have been very rich presentations today. We heard Shamshad Bhai in the morning, Yasmin Appa's presentation, although she kept on saying she doesn't have much. It was quite rich, and of course Saifuddin's was very theoretical. I liked Hilal Bhai's as well, and Nabila also spoke about the muds, which is what I'm going to speak about. Not about muds, but I want to just before I begin my talk, I want to make it very clear that when we speak about Waqf, it is also important to see what else is happening in parallel to Waqf, and by parallel I mean the Hindu endowments, right? So it's like cricket. We all watch cricket, I'm sure. How has that developed? There's the off drive, there's a reverse sweep, there's a yorker, there are bouncers. All these terminologies have entered the lexicon, which has made it that much more interesting and widened the appeal and has gained currency. I would say that has not happened for Waqf in the same sense. And why and how? Well, I'll come to that. So in November 2024, Indian Prime Minister Narendra Modi said, and openly, that there is no place for Waqf in the Indian Constitution. Those are his words. Now, what does that mean? Well, Waqf was spoken as a device which is used for appeasement, which has no place in the Constitution, and that, why do we need Waqf? What is Waqf for? Now, 40 years ago, Gregory Kozlowski, and I'm so glad a lot of people here have actually referred to his work. Gregory Kozlowski was actually a scholar, historian, who worked here in Chicago, actually, in DePaul University, and he wrote a very popular book, which was part of his PhD, Muslim Endowments in Society in British India. In that book, he perceptively noted, and this is 40 years ago, he noted that laws that have been passed on Waqf over the last 50 years have served to discourage the creation of Waqf. Now that's his observation made in the 1980s. Now we are in 2025. This was of course the period when the Congress government was firmly ruling the country and there was no sight of the BJP coming to power. Yet, such an observation by Kozlowski, made after going through a lot of reports and his field work, speaking to officials and Waqifs, has remained with me ever since I read that a few years ago. And why is Kozlowski saying that? So, the 2025 Act now has, of course, created quite a stir, to say the least, among the Muslims of India, and has been challenged in the Supreme Court. We have experts who have spoken about it. It is currently seized of the matter. And so much of the commentary, and understandably so, has revolved around the provisions that are undemocratic, autocratic, they impinge on religious freedom, and various other constitutional guarantees, which are all, of course, correct. However, I strongly believe that one way to unpack this hostile environment against Waqf is by making a comparison between Waqf legislation and laws that were framed over the legal device of the Hindu undivided family and the juridical status of the deity. Now, what do I mean by that? So, Hindu undivided family is actually a way of a device through which you can file your income tax returns in India. So, if you go to the Indian income tax website, you will see categories for individual, corporate, HUF. So, that HUF is actually a category through which Hindu joint families can file their tax returns. Nothing like that exists for the Muslims or any other community member. Juridical status of the deity, again very shortly, it basically means that the deity, the Pratima or the idol or Lord Ram, is basically a judicial person. So Ram Lalla was actually a party in the Janmbhumi case because the deity has a legal personality, they can sue, they can be sued. So when Kozlowski made those remarks, nothing like the 2025 Waqf Amendment Act was anywhere near the horizon, but neither did Kozlowski did what I attempt to do here, which is an attempt to make sense of how colonial legal architecture evolved around Muslim and Hindu endowments. And I would like to begin by quoting a very renowned scholar of religion and Indologist, Jonathan Duncan Derrett. I think he was the supervisor of Rajiv Dhawan and among many of the luminaries. He was at SOAS for a very long time. So Derrett actually said, and I quote, India is a multi-religious state tending towards a secular state, though how far she, or at any rate the Hindus among her citizens, really wish for a truly secular state has been doubted, end quote. So Derrett's assessment came in the wake of his deep examination of Hindu religious endowments in colonial and post-colonial India. I mean, why did he say that? He said that because he was a master. He knew Sanskrit, he knew a lot of languages, he went through the case law, the legislation, and his assessment was the way the laws relating to Hindu endowments have been practiced, have evolved. It doesn't seem that India is on the path to becoming a secular state. Those are his words. And then again, Derrett's assessment, as I said, came in the wake of his deep examination of Hindu religious endowments. But there are also other assessments that give us a sense as to why Waqf or Muslim endowments did not succeed in extracting concessions as much as the Hindu community. In 1863, Arthur Houston, in his book, which was actually very popular with ICS aspirants, and the title was Manual of Hindu and Mohammedan Law as Administered in British India. And he observed, and I quote, open quote, Muslim priesthood owes its origins to individual piety and private munificence rather than to state endowment. And we get a taste of it here, right? We are all here because certain individuals have come together and made this possible. This is what Houston is saying about Muslim priesthood. So what Houston was pointing out is best explained by archival documents I found pertaining to the administration of temples in the princely state of Kishangarh, which was the princely state, and someone was speaking earlier today about how we have to differentiate between British India and the princely states. I think was it Hilal? Pasha. No, I think it was Hilal, I think. So this was a Kishangarh princely state. What did the British president found there? Well, he found that certain temples, if they were approaching the court for redressal or in case of disputes, they were not supposed to file court fees. Now imagine you're approaching courts to get redressal and you don't have to file court fees. So the British president found that at least 7 major temples in this state had special privileges and were exempted from paying court fees, which is, as I said, a normal practice. So the opinion of the British president at that time was that everyone must be equal before the law, and hence all institutions upon approaching the court must pay the prescribed court fees. Why am I saying this? What does this denote? Well, a simple fact that by and large, Muslim denominational endowments or Waqf did not have the same degree of state patronage as their Hindu counterparts. Muslim leaders like Sir Sayyid Ahmed Khan, and I'm also a historian, so I like to go back into history and a bit of archives as well. So Sir Sayyid Ahmed Khan and Sayyid Ameer Ali, they felt the need of British involvement to gain state security and sanctity for Waqf. Sir Sayyid Ahmed actually drafted a model Waqf Amendment, right, in 1877, 1879, which was basically to eliminate the ill effect of the laws of inheritance that was ripping apart the Muslim landed gentry. His proposals, however, were rejected by leading Islamic scholars who thought that this was an interference in the inheritance law. But what he exactly wanted, what the founder of the Aligarh College actually wanted, was to prevent the Waqf from being opened up. Right? The British courts were constantly putting these properties under their glare. Among the opposers to Sir Sayyid Waqf Nama was Sayyid Ameer Ali, who himself, however, very soon realized that Muslim endowments must get some sort of state approval. And why was that necessary? Well, because they knew that the British rule is not going to go away. We need to make use of them. So what did Sayyid Ameer Ali say? In 1882, he wrote to British government saying that we must prevent the misuse of Waqf and use its proceeds for educational advancement of Muslims. And as any historian worth his salt will tell you, the Britishers were fantastic at that. They will immediately write, it will cascade down to the lowest common denominator, and hence they will leave a trail of documents. In this particular case, I figured out that they said that it's too expensive, not warranted, and why should we do that? Especially because they figured out that a lot of Muslims within British India were saying that educational institutions cannot and should not be given funds from the surplus of Muslim religious endowments. Now you might think what these snippets, what relevance do these snippets have on the present day concerns and debates on Waqf? Well, to begin with, I would propose that a major drawback of Waqf has been that all through its colonial and post-colonial afterlives, it has been bracketed as a concept that in its physical manifestation needs to be transparent and be accountable. I mean, that's what we want. That's what Muslim legislators wanted day in and day out. Misuse ho raha hai. The Matwalis are corrupt, which is not wrong, by the way. But the emphasis was, we have to do something about it. And this has been the logic that has guided legislation on Waqf since colonial times, because the object of following a pristine, orthodox, or proper Islam has always been a constant objective behind Waqf reforms. And I'll come to the 1923 Act as well. And this has, of course, found resonance in current policies and debates around Waqf. In paragraph 123 of the interim judgment of the Supreme Court, which came on 12 September 2025, the court observed, and I quote, as early as in 1923, it was noted that instances of such misuse of trust property were unfortunately so common that a Waqf endowment had now come to be regarded by the public as only a clever device to tie up property in order to defeat creditors and generally to evade the law under the cloak of a plausible dedication to the Almighty. Now, this is what the Supreme Court is saying, that, what is wrong? In 1923, this act was passed because the Muslim community themselves had agreed that it was used to, not pay the creditors or just tie up the property. So this is what has been happening. But I propose here that Waqf Registration Act actually, which sought to ensure transparency and accountability in Muslim religious charities, was, I will say, was the first of its kind. Now, what is meant by that? No central law was enacted to regulate it is still the case, as Shamshad Saab pointed out, to regulate Hindu or Parsi religious charities at the central level, and definitely none existed in substantial way before the Mussalman Waqf Registration Act was passed in 1923. Now, this act sought to ensure transparency and accountability in the administration of Muslim endowments or waqfs. For the first time, it introduced a system of registration and oversight requiring that these charitable trusts must be properly noted and made accountable. And in doing so, I think it established a new legal relationship between the colonial state and Muslim religious institutions, which was grounded in surveillance, it was grounded in documentation. If the Mussalman Waqf Amendment Act of 1913 had represented the assertion of Muslim political agency, Jinnah was the one who piloted it, and then we knew how his career went up, affirming the community's right to create and maintain family waqf in the face of colonial skepticism, then the Mussalman Registration Act of 23 may be seen as a culmination of that consciousness. What do I mean by that? Well, this consciousness has taken on a more defensive and arguably commercially restrictive character. By emphasizing regulation, registration, and the separation of sacred property from market forces, the 1923 Act embodied a commercially unaccommodating version of Muslim identity, right? Which is what my wider project is. There's difficulty to imagine Muslim as an economic subject. If they are doing work which is only for religion, pious, charitable purpose, yes. But is there commerce involved? Yes, most definitely. Could you have had certain provisions that could have helped you further those commercial gains? Yes, definitely. Did that happen? No. Why? Because the Muslim publicists and leaders were just saying, oh, there has to be transparency, there has to be accountability. But that was not what was happening on the other side. What was happening there? Here is what I give you a little bit a taste of that. Efforts from Hindu legislators to introduce a bill similar to the 1923 Waqf Registration Act, faced immediate opposition. Dr. H.S. Gore, who was a very liberal Muslim reformer, very widely read and an expert, he made a case for the circulation of Hindu Religious and Charitable Trusts Act Bill in 1924, following the successful passage of the Registration Act. So imagine, now that the Waqf bill has come out, can there be another Hindu Endowment Act paralleling the Waqf? No, no way. I don't think it's possible, right? But this is what was happening 100 years ago. A Hindu legislator stood up and said that we also should have an act similar to the Muslim Registration Act. As soon as he stood up, and it is recorded in the legislative proceedings, which are very lively and they give you a lot of detail, he was reminded, Dr. Gore was reminded, that communities like the Natukotai Chettiars, the Chettiars are a very industrious commercial group in South India. They are into trade and business. So he was told that the Chettiars had a large number of small trusts in almost every family, and if you come up with a bill seeking the Hindu families to record and put it out in the public domain what they are spending on the deity and other endowments, it will be opposed later. You will not be able to pass it. So it's a waste of your time. Similarly, even the mutts, right? A lot of mutts are actually big landowning entities. They will never want you to file this, go ahead with this act, and it will never happen. So what does it mean? Well, it means that while the 23 Waqf Registration Act was enacted at the central level, Gore was told that a better option for this would be to devise laws at the provincial level. And I think perhaps that's the genealogy of why we still don't have a central act for Hindu endowments. And he was told that that is necessary because that will be making those enactments will be responsive to the immediate features of Hindu denominational charities. So don't have a central act, have a provincial act. This contrasted with the situation within the Muslim community. As I said, the act was already passed, where except the Bohra community, and some of you are from Gujarat, or if not even from Gujarat, you will perhaps know who the Bohra community is, what are their beliefs. They were resistant to the Waqf Registration Act. Why were they resistant? Well, because they were into trade and commerce. For them, Waqf was charity, Waqf was pious, but they also had other ways to finance that. And they didn't want all those details to come out in the public domain. So they said, nothing doing. We don't want this act on us. So the Muslim legislators, whole body of Muslims are saying, fantastic act, go ahead. The Bohra are saying, nothing doing. We're not going to do it. So the 1923 Waqf Registration Act, which the Supreme Court has referred to in the way that I did, it was actually one of its kind because the Hindu legislators could not even introduce a similar bill because of expected backlash. So the Waqf Registration Act of 23, by making trustees of religious and public charities accountable, was encouraging transparency in an area that the Hindu trading communities were keenly fighting to keep within their control. So if most of the Hindu trading communities were in favor of keeping the role and function of trustees of the Hindu Endowments Trust concealed, the opposite was true for the Muslims, right? Except the Bohras. So much so that the Bohras actually managed to get an exemption from that in the Bombay province, where they were exempted for a period of around 3 years. So they were not supposed to give out those details. All other Muslim communities were technically giving out those details. So what happened when the Waqf Act was applied to them as well? Because finally the government gave in. The Britishers were told that, the body of opinion is such that Muslims have to follow this law. Let it be more transparent. So the exemption was taken off. In fact, the Muslim League was filing resolutions in the yearly meetings that yes, this Waqf Registration Act must apply to everybody. So the exemption was taken away from the Bohra community. What did they do? A most law-abiding, fantastic community, when they are, I'm not doubting. What did they do? They said, nothing doing. We're not going to file this. We're not going to give details of our endowments to this. Why? Because it's not required. They paid court fines, they faced contempt of court proceedings, few cases went right up to the Privy Council, but they said, no, we don't want to fight. What else did they do? Fantastic. They said, well, these are not Waqf. So this 23 Registration Act that has been filed, that Waqf should give details, it is for Waqfs to give details. Our community, we don't have Waqf. So what do you have? Well, we have trusts. So this act does not apply to us, right? Why? Because they didn't want to share those important details which they thought should be within the community. And this is the genesis of the exemption that the Bohras and Khojas have got in the 2025 Act. However, in the real sense, there is no such exception that they have also got. Because it's just a clause which says that the provision of this 2025 Act will not apply to a trust established by a Muslim, even if it is similar to a Waqf. So they have not got any exemption, it's just a play of words. I must add, however, that the Ministry of Minority Affairs, it's a fantastically rich document that Hilal was also referring to. I went through it. It actually makes so many things that much clear because you understand why they are saying what they are saying. So this particular document I also went through, and it actually said that, yeah, the Dawoodi Bohras must be given exemption. The Indian state is saying that. However, this is the best that the Bohras could get, and the parliamentary committee decided that no, we can't say that Waqf created by this sect will be exempted, and it never made it never went that ahead. But they tried that very hard. So this is the best that even the Bohras could get, for even they have never received the kind of exemption and concessions that Hindu trading communities have received, and I'm sure they know that, but of course, they are pretty smart on that aspect. So a close reading will reveal that property owning deities actually was similar to family Waqf, and we spoke about certain parallels between them. The same way as a Muslim testator is allowed to tie up their assets for the benefit of the family members and descendants. But while family deity did not require any special enactment of law for its juridical status, and case law works towards facilitating its concurrent positioning along with HUF as a device to bind wealthy Hindu families. It remained a fertile source for disputes, but that does not take away from the fact that it has remained a vibrant source for capital accumulation. Now, what do I mean by this? That essentially, if you're not allowed to give a lot of details, you cannot disclose a lot of transactions, which means, you're not disclosing your tax liabilities. And that has been a good, important factor in distinguishing between how much capital accumulation can take place within a sect, a community, or a religious group. Also, there is the concept of common deity. So in some communities, entire villages had a common deity, and then there are mutts, which were treated as private religious corporations. Mutts are monastic institutions which encourage spiritual learning by Hindu ascetics belonging to a particular order. In the case of mutts, the mahant is the manager of the properties and the spiritual head of the mutt. A gift in favor of an idol or a mutt can be made oral as well. How is it different from waqf? We know that there is oral provision, right? Waqf can be made oral. It's the same for them as well. What is not similar is the case of trust, where it has to be put in writing. So you see there is a lot of parallel between Hindu and Muslim endowments. But is the law treating them the same? Well, not really, doesn't look like. A gift in favor of an idol or mutt can be oral, as I said. And the Indian Income Tax Act of 1922 gave tax exemptions to property held by Hindu deities. Section 4, subclause 3 of the 22 Act exempted income derived from these kind of donations or activities. Mutts at temples and family deities are also recipients of the dedication of property, which found acceptance and legitimacy in the colonial legal system in the word debatar. Right, so I spoke about cricket, right? There is a very kind of sophisticated terminology. It just makes it that much interesting. What I will say is, what we are still playing gilli danda, if you know what gilli danda is. Hindu endowments are actually playing sophisticated 5-day proper posh Lord's cricket test match. They have got all the devices with them. The concepts are all there. What do I mean by that? Let me expound a little bit. So the position of shepherds, again something which is used in law, in case laws relating to temples and mosques, mahants, pujaris, with the debatar is quite like that of a manager of a Hindu undivided family, which is actually known as karta. In debatar estates, so debatar is actually dev plus utter. It's I think Bengali extraction, where it means property belonging to God, which is what Waqf will say, right? The property is not with us. Nada Mumtaz book on Lebanon Waqf is titled like that. So debatar estates will be alienated only in circumstances where the benefit could accrue to the deity. Some mutts in North India were involved in heavy trading and money lending activities, right? So they have so much assets that they are giving money on interest, but they are gaining exemptions because they are saying we are a private corporate kind of a structure. So the idioms of preventing misuse and personal aggrandizement were common to Hindu and Muslim political leaders. Both the sides knew that there's a lot of problem that is happening. However, legislative changes concerning Waqf were far more overbearing, and we can see that as evidenced by the 1923 Waqf Registration Act. So the landscape changed a bit when the 1954 Waqf Act facilitated the establishment of Waqf boards. Before that, it was very hush-posh. 54 Act just facilitated that each state can start having Waqf boards. And because they were part of the executive machinery, usually kind of Muslim bureaucrats heading them, they had all the trappings of a bureaucrat, of a government department. And so they acted like one, right? This is what happens in India. You have the setup, a bureaucrat is heading it, you're semi-part of the government machinery, you act like a government office. It just comes very naturally to South Asians, right? So it was the same with the Waqf board. Why is that important? Well, because they have to then start acting like a government body. And in a federal system like India, I also try to look at it in a different way. In a federal system like India, disputes over land and properties are not uncommon between entities like railways, port trusts, municipalities versus the state or the central government, right? They say, no, this land actually belongs to us, and they keep on fighting. So in the right spirit, Waqf boards should also be seen in the same light. I mean, what is the difference? The difference is they are Muslim, right? That is the difference. But it is also a body that seeks to protect assets that it believes come under its jurisdiction. That's exactly what they're saying. Oh, no, this seems to be a Waqf land. And of course, it will go through a process. Why are you cutting the process? In Delhi, the Sunni Majlis-e-Awqaf, and I go a little bit into history, the predecessor of the Delhi Waqf Board intervened in several cases involving individuals and families who left behind Waqf properties in Delhi. And they were not really successful. Why? because the district judge of Delhi would dismiss these applications by the Majlis, seeking to look after or take over Waqf properties that were left behind those who went over to Pakistan. And why would that happen? Because the district judge will say that the custodian had said that this is an evacuee property. So, nothing can be done. It has already been defined. So they will very rarely interfere if the custodian has declared so. Among the leading lights of the Majlis-e-Awqaf were individuals like Nawabzada Liaquat Ali and Dr. Zakir Hussain. So if some of you who will know, for the benefit who might not know, Liaquat Ali went on to become the Prime Minister of Pakistan. Zakir Hussain became the President of India. Why is that important? Well, because it just signifies that appointments to Waqf boards have been top-heavy. But it did not mean that they had much teeth. In the early 1950s, it was discovered that the Jama Masjid was running in deficit. Right? Or did I not put that bit? Yeah, it was running in deficit. They had shops which could give out rent to the tune of thousands of rupees. Over 2 lakh rent was outstanding. No effort was being made to, get those back. But what was happening? The Majlis was spending thousands of rupees in opening offices. There are far too many tales of corruption and fraud in the Waqf boards, but one cannot throw the baby with the bath water. That will be stupid, right? That's what the act is doing, I would say. In the late 1950s, the central government took a decision to relinquish. Now here comes the Nehruvian India, where actually it did come up with some interesting and quite liberal policies. So the family Waqf beneficiaries were again divided. A lot of brothers or sisters went over to Pakistan, and the government said that the entire family Waqf is evacuated. But then they realized that it's not that whole families have just vanished to Pakistan. There are some who are still in India. So if there is a family Waqf, let us release those properties for the benefit of the non-evacuee beneficiaries, which is the people who are still in India and they have family Waqf, but their brothers or sisters or uncles have gone there. I would say it was a very, very liberal sort of act. So it was also pointed out by New Delhi itself that the neighboring country had taken a completely different stand on Waqfs established by non-Muslims. So Waqfs are also established by non-Muslims, by the way. And Nehru in India was saying that, look, we have released these properties, but that's not what Pakistan is doing. But it was not so kind of all nice and very fantastic. Here is a letter that I discovered in the archive. The Waqf Hooghly Imambara in West Bengal was financed largely from income directed in West Bengal. What happens in Pakistan when partition took place? Sorry. So this Imambara is now in West Bengal, but it was financed by property which now lies in East Pakistan, or which became Bangladesh. So when the partition takes place, this particular property has come under India, but the assets which are generating those income are still in Pakistan, in Bangladesh now. So what will happen? Well, for a century or so, the collector of Khulna used to transfer money to the collector of Hooghly for around a century for the upkeep of the Imambara. But because Waqf was not included as a point of discussion in inter-government proceedings and negotiations between India and Pakistan did not include the point of Waqf, the Hooghly Imambara suffered immensely because they were not getting that fund that was actually tied up to the upkeep of this property. And here is a letter that Prince Yusuf Mirza has written to Nehru, saying that there's this partition paralysis, I tried to call it, and saying that you have to do something because that's the assets that's going to finance us. So there were a lot of troubles and problems all along. Here is another lady writing from Bhopal, and I found the masthead fantastic. And I get very enchanted by these finds. National School, it says, and she's saying that Maulana Azad has actually got this person sacked because he was troubling me so much, not releasing my properties, and everything has been released. One property is still there. So can you do something about it? And I mean, I don't know what happened to that, but what I'm trying to say is that these conversations were happening, and the government had certain problems, but they were keeping things in some sort of a balance. The other bit that I wanted to show one is, so look at this. This is something which I found from the 1980s. right? The Indian Archives is opening up, by the way. And if you are interested and you have few hours to spare, then please go to Abhinek Patar and you'll find fantastic documents. This is one that I located in the archive. What does it say? Well, look at 6. The Delhi Waqf Act should be amended to exclude notification of government property as waqf, which is what has now come in 2025. So nothing happens in a day. Right? That mentality builds up. That attitude is there. It just needs a proper expression. Now this is 1980s, and the Ministry of Home Affairs that's saying that, because that matter is still very hot, actually, the 123 work properties, and I have written a paper for it for somewhere else. The Home Affairs Ministry is saying that, they're just fed up with these Waqf guys saying that this is government property, Nothing like it. Let's put a stop to it. So what do? Well, let's amend the Delhi Waqf Act so that, the government properties cannot be notified as Waqf at all. So this is 1985, and this is 2025. So we can see the progression. What can we do? Well, I will say that, have a more comparative framework. Instead of us talking about that Waqf is fundamental and this has been always there, it's centuries old, which is all correct. Let us also speak about what other communities are doing. Are they getting anything better? Have they benefited? Have they been kind of faced roadblocks? What has happened to them? Because it's not just Muslims who are living in India. There are Parsis, there are Christians, there are also Hindus. So what is happening to their end of it? Can we include that to kind of have a more stronger narrative? Maybe we can. And as I said, let's speak about the other devices that were created. We spoke about the 1913 Act, that, it did fantastic and all of that. The HUF and family deities, there was no act that was passed for it. At least I haven't found. How did it happen? It just happened through case law. It was taken as normal, right? So nobody says that, there was no law passed. There were laws passed for the Muslims, but there were no laws passed for the Hindus because we never required it. It was accepted as common sense, right? So these things have to be included in our conversation to try and make it a bit more interesting and appealing to the others. And of course, as I try, riding 2 horses of academia and journalism, I try to do my bit by writing whatever little we can. This was one article I wrote which tried to make sense about the Waqf Act and what it means for the Bohras, what is the historiography to it. So I would like to end with that, just with the point that, we all must engage at our own levels. We are all interested in things. There is WhatsApp, there is everything, so make most productive use of it and, think of ways on how we can counter things. So that's about it. Thank you so much for your attention.